Hello, welcome back to the Employment Hour. I'm your host, Paul Cotillo, along with Jeff Williams. We're interviewing Mr. Charles Krugel, Human Resources Attorney and Consultant. Charles, welcome back.
Thanks.
And we were, at the end of the last segment, we were talking about employment at will.
Yeah.
Can you explain that a little bit to us?
Yeah, the doctrine, and this applies in Illinois and a lot of states across the country, is that you can basically fire somebody. An employer can fire an employee for any reason, any time, with or without cause or notice. Vice versa, an employee can quit the employer any time, any reason, with or without notice. So
that sounds very more of advantage to the employer than it is the employee. Doesn't the employer have to give warning or give notice number 1 or notice number 2 or notice number 3, or is that just something that they do as organizations to kind of cushion themselves or whatever?
Well, it depends. Depending on the layoff. I mean, if you have to give there's a federal law, WARN, and that I can't remember off the top of my head what the acronym itself means, but you may have to give a WARN notice to employees regarding a layoff. I think that's 100 or more employees, and depending on the number being laid off too. But if it's just for like a smaller employee and not for a layoff for disciplinary reasons or for a layoff of a smaller size, no, you don't necessarily have to give notice, but it's a good idea. Human resource doctrine or human resource practice-wise is a good idea to do that, and then also to possibly insulate yourself from unemployment comp or for allegations of wrongful discharge, discrimination, what have you, to give notice. In some cases, multiple notice.
Now, how does the employment at will concept, how does that interface with union negotiated contracts?
Well, union negotiated contracts really have almost nothing to do with employment at will, because it's the concept that employment at will, there is no contract, technically. With a union, there is a contract. So you're basically completely mitigating or taking away the concept of employment at will, and you're going to basically contractual-based or contract-based employment with the unionized employees and their representative.
So if you had a facility
that
had both unionized and non-unionized workers, you could have two very different dismissal systems in the same building.
Not only that, if you have a facility where this happens a lot, like with public sector and also some manufacturing facilities with multiple unions, so you could have different contracts governing different employees and different systems regulating how those employees are promoted, terminated, compensated, laid off, everything.
Well, how does the employee, I mean, how do you develop any type of protection for yourself? I mean, you're not really guaranteed anything. You're not even guaranteed a letter of recommendation. You're not guaranteed advance notice before you're fired. What can the employee do to try to level the situation for themselves? Because this is not a level playing field.
Well, let's look at it this way too. There's no guaranteed success either for the employer. You know, in our economy, a market-based economy, technically there is no guarantee of success. Now, you know, we all know realistically that the airlines and some of the car manufacturers, they get government aid, or the defense contractors, they do get government aid. But you know, then again, you could argue so do employees. But no, technically there's no guarantee, and it works the same way to almost the same extent, I would say, or the same extent for employers. But what an employee can basically do is make sure that they're right fit for the job, make sure that they're going to a company that they want to work for if they have that luxury available to them, and if not, then just do the work and try not to sometimes I get angry employees asking me, what can we do? And it's like, do the job or look for another job. If not, as long as they're not just treating you poorly on the basis of any protected class, you basically have to bear with it as an employee. It could be the unfortunate reality. Then again, there's also this way to look at it. Bad management isn't necessarily illegal. And you see a lot of bad management in the workplace too. So,
very interesting concept, really. But when a person gets employed by an employer, you're really on their turf, right? And you have to kind of go along with their rules and how they want to do things or whatever, or you're gone. Am I right? Mm-hmm.
Unless you have what Jeff brought up regarding collective bargaining agreement protecting you, or if you're an individual employee who has your own individual employment agreement. And employment agreements, individual contracts seem to be becoming more popular in the workplace too. especially with more highly placed executives.
And then on the other side of that too, the better employers don't just hire people and then a couple weeks later let them go or you know, fire them for seemingly no reason or whatever. That creates a bad morale and creates employees that really become bitter against the management. Am I correct?
Yeah, it gives them a bad reputation in the industry. And it costs a lot more money basically to fire people. Firing people should always be a last resort. Layoffs should always be a last resort. The concept of what's called human capital is that employees are the same as any other piece of capital that you have in your business. Why would you destroy capital? What good would that do for you if that's the means of production and making a profit? So treat your employees well in order to get the most out of them is basically the human capital philosophy, or what seems to work best in human resources. And on the back end, it's just going to cost a lot more money anyway to fire them, and then they have to go through hiring and training somebody again.
When you see the upper echelon companies, as far as their top management reputations,
Yeah.
what kind of processes are you seeing in personnel to try to remediate people that are not performing quite as well? What types of systems are you seeing that the smarter companies put in place?
Well, they give people either multiple chances or try to move them to positions that they work better in. See if there's, for larger companies, it's easier to shift somebody to another department or a large organization, even if it's not a private sector company. You could shift them to another area, retrain them, or get them more training for their area. Those are generally what you see the most of, or outplacement services. If you do have to fire them, get them quality outplacement services.
I want to talk a little bit about firing. There are laws that govern that also. Am I correct?
Well, you can't fire on the on the basis of the protected class, but there's no laws in terms of the logistics of firing unless you're getting into layoff under the Warren Act. So.
Okay, could you explain that a little bit more?
Well, basically, if I've fired people before, and I do it, largely the same way we're sitting here talking. I mean, you explain to somebody why they're being fired, and if there's documentation, what the documentation itself indicates. There are laws regarding the viewing of their personnel file and attaching rebuttals to documentation that they disagree with. There's laws regarding that, but there is no law regarding the actual logistics of it. But there, so that part, no, there's no law. I mean, there is a law regarding continuation of benefits. They have benefits. There could be contractual obligations relative to severance, things like that.
I've read that in some states, among employees fired, there could be a significant percentage that are declared ineligible for unemployment insurance. What helps to determine whether, when you're dismissed, you're eligible for unemployment?
Generally, if it's a layoff, you're eligible because the employee, him or herself, didn't create the cause of their unemployment. Generally, that's what you look at relative to unemployment comp, how the unemployment situation itself was created. This is basically an insurance fund, a pool of money designed to help people in transition from one job to another during any time off or during periods of underemployment where they're not getting enough hours. So basically, if it's due to performance and some forms of misconduct where maybe it was a lighter or not a completely proven sort of misconduct, there's a greater chance, a likelihood of getting unemployment comp. So let's say a person was fired due to theft, but yet there's no proof of any of that. The employer never documented it. That would be the proof. There's no documentation, anything like that, for the employer to cover themselves with respect to the theft. Then it's possible to get unemployment comp in that situation. If it was performance, and they basically just fired him without any warning or anything like that, in that situation, it's possible that you would get, as an employee, you would get unemployment comp. And that is, like as I said earlier, one of the mitigating factors of the doctrine of employment at will. And
the employer does pay into employment comp, right, for his organization, am I correct?
Yeah.
Okay,
that's right.
And that's kind of an insurance policy, am I correct?
Yeah, it's generally it's regulated by the states. It's a statewide insurance fund that all employers pay
into. Okay, we're going down to a break now at this time. So thank you all for watching, and keep watching us in our next segment. And once again, check out our website, www.employmenthour.com. You'll find all kinds of information if you're looking for a job, if you have a job and you want to improve your job, etc. Thank you for watching. We'll be right back.